Karen had timed it for a Tuesday afternoon. She knew my schedule. 3 years of living next door had given her that. She knew I left at 7 and came home at 5:30, and she had used that window with the specific precision of someone who had been planning this for longer than the act itself took to execute. I stood at my back gate at 5:47 and looked at what used to be my pool. The water was gone. In its place was a grey, slowly hardening mass, wet concrete, poured from above, filling the deep end in uneven layers, the surface already beginning to crust at the edges where it had contacted the dry walls. The pump housing was buried. The return jets were buried. The light fixture in the deep end wall, the one I had replaced 2 summers ago with an LED unit, was buried. $40,000 of pool infrastructure, buried under approximately 3 cubic yards of ready-mix concrete. I stood at the gate for a long time. I did not call Karen. I did not go to her door. I took out my phone and I called 3 people in sequence: my attorney, the police, and my wife Vera, who was still at her office and who, when I told her what I was looking at, said nothing for 4 seconds and then said, quietly and with the specific precision of a woman who had spent 20 years as a criminal prosecutor, "We are going to need photographs of everything before anything else moves or dries." I took 41 photographs before the police arrived. What happened in the 4 months after those photographs were taken, what Karen lost, what she paid, what she could not buy back, that was not about the pool. The pool was just the thing she destroyed. What she destroyed along with it was the story she had been telling herself for 3 years about what she was allowed to do and why. My name is Roland Ash, 52 years old, 23 years as a licensed structural engineer in the state of Colorado, the last 11 running my own firm. I design things that are meant to last. I understand load-bearing capacity, material failure points, and the specific and irreversible consequences of applying the wrong substance to the wrong structure. I know exactly what concrete does to a pool. My wife Vera Ash spent 11 years as a deputy district attorney in Jefferson County before moving into private practice, where she now runs a boutique criminal defense firm. She understands evidence, chain of custody, prosecutorial standards, and the difference between a civil matter and a criminal one. Karen Prout had moved next door to the 2 least appropriate people in Colorado for this particular act. We had bought our home in Ridgeview Commons 4 years ago, a 4-bedroom contemporary on a half-acre lot in an HOA outside Denver, 59 homes, mountain views from the upper floors, the kind of development where people paid a premium for the combination of community and privacy and understood, generally, where one ended and the other began. Our pool had been installed in year 1. I had engineered the structural specifications myself: gunite construction, 9 feet at the deep end, a bench along the shallow end that Vera used for reading on Sunday afternoons, deck drainage designed to handle Colorado's precipitation variability, premium equipment, automated chemistry management, the kind of installation that reflected the fact that I do not build things casually. It had taken 14 months to complete from permit to first swim. I had been involved in every decision. Karen Prout Cassidy lived directly adjacent to our east property line. She was 54, former landscape architect, and this detail became significant later, now what she described as a residential design consultant, which appeared to mean she had opinions about how other people's properties should look, and was willing to express those opinions in escalating ways when the properties in question did not conform to her aesthetic preferences. The pool was, from Karen's perspective, wrong. Not in a legal sense, not in any sense that connected to code or ordinance or HOA regulation. In an aesthetic sense, a personal, architectural, deeply held conviction that a pool of our design, contemporary, geometric, the long rectangular form that I had specified because it suited the property's sight lines and my wife's swimming habits, was incompatible with what she called the naturalistic character of the neighborhood. She expressed this conviction to us directly at a dinner party hosted by our mutual neighbor Bate Calloway in our 2nd year. She said it conversationally, with the tone of someone offering useful feedback. Rectangular pools, she said, were a 90s aesthetic that disrupted organic landscape flow. She had used the phrase landscape harmony twice. Vera had looked at her with the expression she used when a witness said something that would become significant later. I had said politely that we were pleased with the pool and that the design had been carefully considered. Karen had nodded in the way people nod when they have decided your response is not the end of the conversation. The complaint started 3 months later. The first was submitted to the HOA board, a man named Gregory Hallstrom, retired civil attorney, who ran our board with the careful precision of a lawyer who understood liability. Karen's complaint cited aesthetic incompatibility with Ridgeview Commons community standards. She had attached 3 photographs of our pool taken from a standing position above our shared fence line, annotated with what appeared to be landscape architecture terminology. Gregory reviewed the complaint, reviewed the CC and RS, and sent Karen a letter noting that the HOA's architectural standards governed new construction and modifications, that our pool had been approved during the installation permit process, and that aesthetic preference did not constitute a standards violation. Karen submitted a second complaint 4 weeks later. This one cited what she described as light reflection issues. The pool's surface, she claimed, created glare that affected her enjoyment of her eastern garden during morning hours. She had attached a chart showing sun angles and reflection trajectories. As a structural engineer who understood light behavior in material surfaces, I reviewed her chart. The geometry was incorrect. The angles she had cited would produce the described reflection approximately 4 days per year, at solar positions that occurred only during the spring equinox period. I submitted a brief technical rebuttal to Gregory, who reviewed both documents and dismissed the complaint. The third complaint alleged that our pool pump created noise exceeding HOA acceptable limits. Karen had attached a decibel reading taken from, based on the described methodology, a position approximately 8 feet from our equipment housing, which was mounted on the exterior wall of our pool mechanical room on the west side of the property, away from her property. Vera had obtained the HOA's noise standard. Our equipment was rated below it by 17 decibels at source. At Karen's property line, the attenuation through 2 fence panels and 15 feet of distance would reduce that figure further. Gregory dismissed the complaint. Between months 4 and 18, Karen filed 11 complaints with the HOA. Gregory dismissed 10 of them. The 11th, a claim that our pool lighting after 9 p.m. violated HOA nuisance standards, resulted in a letter asking us to consider reducing pool lighting duration. We voluntarily adjusted our timer to shut off at 8:45, not because the complaint had merit, but because Gregory had asked politely and we were not interested in conflict for its own sake. Karen interpreted the one partial success as confirmation that the complaint process was productive. The complaints continued. I began the documentation log at month 6. A physical notebook, dated, sequential, every complaint, every dismissal, every communication. My engineering training made me constitutionally incapable of not keeping records. Vera had encouraged it from the first complaint, for reasons that were professional and that I did not fully appreciate until much later. At month 18, the complaint process appeared to exhaust itself. Gregory had dismissed 12 consecutive complaints. Karen had apparently concluded that the board was not going to be useful to her. The complaints stopped. What replaced them was something different. Month 19. I came home to find that the ornamental grasses Karen had planted along our shared fence line, planted, I noticed, on her side, but positioned so they grew through the lower fence rails, had been trimmed back from her side, but left extending through the rails onto our pool deck. The cut ends were visible on her side. The extending portions on our side were intact. Growing now without their root side counterparts trimmed and directing all growth pressure outward into our deck space. This was not accidental. As a landscape architect, Karen understood plant growth behavior with professional precision. She had created a one-directional growth pressure designed to eventually lift our deck pavers. I documented it, photographed the cut ends on her side and the extensions on our side, trimmed the extensions from our side cleanly. Month 22, I noticed that the drainage flow from Karen's property had changed. Our properties shared a natural drainage gradient, with both yards sloping toward the back boundary. The historical flow had been sheet flow, dispersed across both yards toward the retention swale along the rear. Karen had installed a new landscape berm, attractive, naturalistic, the work of a professional landscape architect, that had altered the flow concentration, directing a higher volume of water toward the gap between our fence and her garage, directly toward our pool equipment housing. As a structural engineer who specialized in drainage design, I recognized what had been done immediately. The berm was not accidental. It was precise. It was the work of someone who understood hydrology and had applied that understanding to create a directed water concentration aimed at infrastructure they wanted to damage. I documented it, photographed the berm from multiple angles, hired a licensed civil engineer colleague to provide a written assessment of the drainage alteration and its effects. His report confirmed the redirection and estimated that, over 2 to 3 years, the concentrated flow would cause foundation erosion around the equipment housing sufficient to compromise the structural integrity of the mounting pad. I had the mounting pad inspected, reinforced, and waterproofed. Then I sent Karen a certified letter. First one, formal, factual, drafted with Vera's review. Documented the drainage alteration, attached the engineer's report, stated that the modification had created a directed water hazard affecting our property infrastructure, requested that the berm be modified to restore historical drainage patterns, and noted that if property damage resulted, I would pursue all available legal remedies. Karen's written response, received 2 weeks later, said the berm was a landscape improvement within her property and that she had no obligation to maintain drainage patterns for her neighbor's benefit. She was not entirely wrong about this in a narrow legal sense. Vera spent 2 evenings researching Colorado water rights and drainage law and concluded that the letter had limited direct legal traction unless we could document actual damage, which had not yet occurred. I reinforced the equipment pad further, added a drainage diversion channel properly permitted that redirected the concentrated flow before it reached the pad. The solution was elegant from an engineering perspective and completely neutralized Karen's redirection. She stood at her fence the day I finished and watched me work, said nothing. Month 26. The ornamental grasses came back, replanted, a new variety with more aggressive lateral growth. I trimmed them quarterly. Month 28. I found that 3 of our pool deck pavers on the east side, the side adjacent to Karen's property, had been disturbed, not lifted fully, shifted by approximately a quarter inch, in a pattern consistent with something being inserted beneath them and levered. There was fresh soil visible at the edges of 2 of the disturbed pavers. I documented this carefully, replaced the pavers, had the substrate beneath them inspected, found nothing inserted, but found evidence of recent excavation along the edge. Someone had dug carefully along the paver edge and replaced the substrate material. I could not prove this was Karen. I added it to the log with a notation, origin undetermined, pattern consistent with deliberate disturbance. Month 30. Vera came home from her office one Wednesday evening and said, without preamble, I want you to install cameras on the east side of the property. I already had 2 general security cameras. She meant dedicated, high-resolution, continuous recording cameras positioned specifically to capture every inch of the east fence line and pool deck. You think she's escalating, I said. I think she's a landscape architect who has been running a 3-year campaign to damage your pool infrastructure using her professional knowledge, Vera said. And I think she's frustrated that none of it has worked. Frustrated people escalate. I installed 4 cameras the following weekend, 2 on the house eve covering the east fence line at different angles, 1 on the pool mechanical room covering the equipment pad, 1 on the rear fence post covering the back of the pool deck. All 4 were high-resolution, night vision capable, continuous recording with 30-day storage, cloud-backed. I did not tell Karen they were there. I was not required to. Colorado is a one-party consent state for recording on your own property. Month 31, nothing on camera from Karen's direction. Month 32, nothing. Month 33, on a Tuesday morning at 7:22, after I had left for work, the east fence gate opened. Karen entered my property. She walked directly to the pool equipment housing, spent 4 minutes at the housing, and left. I watched this on my phone at my office. I rewound it twice, then I called Vera. She went to the equipment housing, I said. What did she do there? I can't tell from the angle, but she spent 4 minutes. Vera was quiet for a moment. I'm calling Gregory Hallstrom. Wait, I said. I want to know what she did first. Roland. I need to inspect the equipment before we involve anyone. If she tampered with something, I need to document the tampered state before it's disturbed further. A pause. You're right, go now. I left my office, drove home in 26 minutes, walked directly to the equipment housing. She had introduced a substance into the chemical feeder. I identified it by sight and smell. It was a highly concentrated algaecide, the kind used in commercial landscape maintenance, far above residential pool application rates. Introduced directly into the feeder in sufficient quantity that if the system had run normally, it would have crashed the pool chemistry comprehensively, potentially damaged the liner, definitely rendered the pool unusable for weeks. I removed the substance, documented it, photographed it in context, and separately sent a sample to a laboratory for analysis. Then I called Vera. Chemical tampering, I said, commercial-grade algaecide in the feeder. The pause on her end was the pause of a prosecutor identifying a charge. That's criminal mischief under Colorado Revised Statute 184501. Value of potential damage, time to restoration, and professional assessment determine the degree. I have it on camera, I said. 4 minutes at the housing, clear identification. Another pause. We need to decide something right now. Do we call police today, or do we wait and document further? I thought about this, about the 3-year log, about 11 HOA complaints, about the drainage berm and the grass and the disturbed pavers and now chemical tampering on camera. We wait, I said. I want the full picture documented before we go to law enforcement. I want them to see the entire 3 years, not just today. Vera was quiet for a long moment. That's a risk. I know. If she escalates further while we're waiting. Then we have more documentation, I said, and a stronger case. She did not answer immediately. She was thinking the way she thought when she was assessing a legal strategy, the specific silence of a person running variables. 3 weeks, she said. We document for 3 weeks, then we go to law enforcement regardless. Agreed. I sent Karen a second certified letter that evening. I did not mention the chemical tampering. I did not mention the cameras. The letter cited the history of complaints and property interference and stated formally that I was documenting all interactions involving my property and that any damage to pool infrastructure would be addressed through every available legal remedy. I wanted her to receive correspondence from me on that date. I wanted the postmark in the record. She signed for it Thursday morning. The 3 weeks passed. No further camera activations from Karen's direction. I checked the pool chemistry daily. The equipment was running cleanly. The removed substance had caused no damage. On the 22nd day, at 7:14 on a Tuesday morning, as I was backing out of my driveway, I saw a cement truck parked 2 streets over, an unusual sight in our neighborhood. I noted it without concern and went to work. At 5:47, I came home to what I had described at the beginning of this account. I stood at my back gate for a long time. The cement was setting. The pump housing was buried. The light was buried. The deep end was filling from the bottom with a material that bonds permanently to concrete surfaces that, once fully cured, would require mechanical demolition to remove, during which process the pool shell itself would be at high risk of structural damage. I took 41 photographs. Then I called my attorney, then the police, then Vera. Vera arrived home at 6:40. She stood at the gate beside me and looked at what Karen had done in the specific way of a woman who has spent 20 years assessing crime scenes. She did not say anything for a long time. Then she said, "Pull up the camera footage." We pulled it up on my phone at the gate. The east fence camera showed Karen entering at 10:53 a.m. She was carrying what appeared to be a remote control device. She spent 3 minutes at our pool gate. The footage showed her operating something at the latch, and the gate opened. She went inside, walked to the pool edge, made a phone call. At 11:12, a cement truck appeared at the rear of our property, accessing from the easement road that ran along our back boundary. The driver remained in the truck. Karen directed 2 men who had come in the truck bed. They ran a chute from the truck over our fence line into the pool. The pour took 22 minutes. They were gone by 11:40. Karen stayed for an additional 4 minutes, looking at what she had done. Then she left through the gate, which she closed behind her. The entire sequence was captured on 3 of the 4 cameras at various angles. Karen's face was clearly visible in 7 frames. The cement truck's plates were visible in 2 frames. The 2 men were partially visible. I showed the footage to Officer Reeves when he arrived at 6:58. He watched it twice on my phone without speaking. Then he looked at the pool, now fully set in the deep end, with the curing surface visible. He said, "I need to call my sergeant." The sergeant arrived at 7:20. He watched the footage. He looked at the pool. He asked me for the camera's storage information and requested that I preserve the footage without deletion. "We're going to need a detective on this," he said. "This is not a misdemeanor situation." Vera, standing beside me, said, "Colorado Revised Statute 1845-1, Criminal Mischief. The replacement cost of a gunite pool of this specification is between $60,000 and $90,000. That's a Class 3 felony." The sergeant looked at her. "Ma'am, are you?" "Former Deputy District Attorney, Jefferson County, currently private criminal defense practice." She handed him her card. "My husband is a structural engineer. He can provide a professional assessment of the damage value this evening." The sergeant took the card. "We'll need that assessment." I spent the following 2 hours writing a formal structural engineering assessment of the damage. As a licensed structural engineer who had designed and overseen the construction of this specific pool, I had complete knowledge of the materials, specifications, and replacement costs. The assessment was detailed, methodical, and documented replacement value at $74,000, with an additional estimate of $40,000 to $60,000 for demolition of the introduced concrete, depending on the extent of bonding to the shell. Total documented damage, between $114,000 and $134,000. Vera reviewed the assessment before I submitted it. She added 2 footnotes referencing Colorado case law on damage valuation in criminal mischief prosecutions. Detective Sarah Umen arrived at 9:15. She was thorough, organized, and had the specific quality of a detective who has worked property crime long enough to recognize premeditation when she sees it. She reviewed the camera footage, the structural assessment, the certified letter documentation. I gave her the entire 3-year log and the lab analysis of the algaecide sample from month 33. She asked me, when she had finished reviewing everything, how long I had been keeping records. 3 years and 2 months, I said, from the first HOA complaint. She looked at the log, the lab report, the certified letters, the engineering assessment. You prepared for something serious. My wife suggested thorough documentation from the beginning, I said. She was right. Detective Umen looked at Vera. Vera said nothing, which was the correct response. Karen was arrested at her home at 11:40 that night. The cement truck driver, located through plate identification within 4 hours, had confirmed the delivery location and Karen's identity as the person who had contracted and directed the pour. The 2 additional men were identified through the truck company's employment records. The charge was criminal mischief, Class 3 felony, based on the documented damage value exceeding $100,000. Her husband, Frank Cassidy, called me the following morning. He had not been home when the arrest was made. He had been in Phoenix for work. He learned about it from the Jefferson County arrest records, which are public, and from a phone call from Karen's attorney at 6 a.m. He called me from his hotel room. His voice had the quality of a man who has received information that has reorganized everything he thought he knew about his life and has not yet finished processing it. "Mr. Ash," he said, I don't know what to say." "You don't have to say anything, Frank." "I knew she was unhappy about the pool. I knew she'd filed complaints. I didn't know," he stopped. "The algaecide in November, did she?" "Yes, I have it on camera." A long silence. "Is there anything," he started and stopped again. "I know you have every right to pursue this fully. I know there's nothing I can say that changes what she did. His voice broke slightly. I'm sorry this happened to your property, and I'm sorry for whatever drove her to." He couldn't finish it. "I appreciate you calling, Frank," I said. He hung up. I set the phone down. Vera was at the kitchen table. She had heard the call. "He didn't know," she said. "No." "The algaecide either?" "No." She was quiet for a moment. "That's a hard morning to wake up to." "Yes," I said, "it is." The HOA meeting was called for the following Thursday. Gregory Hallstrom had notified all 59 households of the situation, not the criminal proceedings specifically, but the property damage incident and the police involvement. Attendance was 44 homeowners. Gregory ran it with the precision of a retired civil attorney who understood that a meeting involving active criminal proceedings required careful procedural management. I did not present a case. There was no case to present to the HOA. The matter was in the hands of law enforcement and would be adjudicated in criminal court. What I provided to Gregory for the formal record was a copy of the 3-year incident documentation, the engineering damage assessment, and a brief written summary of the sequence of events. Gregory read the summary aloud at the meeting. The room was very quiet throughout. He then said, clearly and for the record, that the HOA had no involvement in the criminal matter, that any civil action I chose to pursue was separate from HOA proceedings, and that the board would be reviewing its complaint process to assess whether the 11 complaints filed by Mrs. Pruitt Cassidy had been handled appropriately. He concluded by moving to formally document that the HOA's architectural standards had been correctly applied throughout the complaint process, and that no legitimate standards violations had existed at any point regarding our pool. The vote was unanimous, 43-0. Karen's single ally on the board, a woman named Diane Pratt, who had been sympathetic to the aesthetic argument, abstained. She did not vote against the motion. In the parking lot afterward, Gregory found me before I reached my car. 3 years, he said. Yes. You documented 11 complaints. And everything between the complaints, I said. The drainage berm, the grasses, the chemical tampering, all of it. He looked at me with the specific expression of a retired civil attorney who has spent his career thinking about documentation and its consequences. The chemical tampering in November. You had it on camera and you didn't come to me. I was building the complete record, I said. You would have intervened. That intervention would have produced denials, an incomplete picture, and a civil matter instead of a criminal one. He was quiet for a moment. That's a legally sophisticated decision. I'm married to a former prosecutor. He almost smiled. Yes, I'm aware. He looked at the sky, the particular deep blue of a Colorado evening. What do you need from the board going forward? Nothing right now, I said. The matter is in the right hands. And the pool. I'm filing a civil suit for damages concurrent with the criminal prosecution. Between the two proceedings, Karen Pruitt Cassidy is going to pay for what she destroyed. Gregory nodded slowly. I'll say one thing, he said. In 21 years on this board, I've dismissed a lot of frivolous complaints. I always wondered with hers whether there was something underneath them I wasn't seeing. There was, I said. A person who had decided she had the right to control someone else's property because she found it aesthetically objectionable. That's not a right that exists anywhere, he said. No, I said, it isn't. He drove away. The criminal case moved with the particular momentum that cases move when the evidence is complete, documented, and professionally presented. Vera was not involved in the prosecution. She was defense practice now, and the conflict of interest was obvious. But she understood the process from the inside and tracked every development with the attention of someone who has spent a career in the same courthouse. Karen's attorney filed 2 motions in the first 30 days. Both were denied. The camera footage was admitted without challenge. The recording had been made on private property, properly disclosed, and the chain of custody was documented by my engineering-grade record keeping. In month 2, Karen's attorney began plea discussions with the Jefferson County District Attorney's Office. Frank had retained a civil attorney as well, separate from Karen's criminal defense counsel, and reached out to Vera about a parallel civil settlement discussion. Vera handled this arm's length, with clinical precision and the complete emotional detachment of a woman who had watched her pool destroyed on a camera feed. The civil settlement was reached before the criminal matter concluded. Frank, who owned the marital property jointly with Karen, was motivated to resolve the civil exposure efficiently and had the resources to do it. The settlement figure, which I will not specify in exact terms, covered the full replacement cost of the pool, the cost of demolition and debris removal, landscape restoration for the areas damaged during the demolition process, and an additional component that Vera had specified in the demand letter as consequential damages for 3 years of documented harassment and property interference. It was a significant number. Vera reviewed the final draft settlement agreement at our kitchen table. She signed as my representative. I signed as the damaged party. The wire transfer arrived 11 days later. The criminal matter resolved in month 4. Karen entered a guilty plea to a reduced charge, Class 4 felony criminal mischief, reduced from Class 3 in exchange for the plea and full cooperation with the identification and prosecution of the 2 men who had assisted her. The reduction was appropriate, and I did not object to it. The men were employees of the cement company's contract labor pool who had been told, apparently, that Karen was doing permitted work on her own property. They had committed a wrong through negligence rather than malice. The distinction mattered. Karen was sentenced to 2 years of supervised probation, 200 hours of community service, a permanent criminal record, and a formal court order prohibiting contact with our property and persons. The court order was enforceable as contempt of criminal court, which has more immediate consequences than a civil restraining order. Her landscape consulting practice, which had been operating under her professional license, was reviewed by the Colorado Department of Regulatory Agencies following the conviction. A professional license hearing was scheduled. I did not attend the hearing. I submitted written documentation of the drainage berm incident and the algaecide tampering to the DORA investigator when she requested it. What the hearing board decided was their professional judgment to make. What I know is that Karen Pruitt-Cassidy's landscape consulting business did not survive the following year. Frank sold the house in month 5 of the criminal proceedings. He had been commuting to Phoenix anyway. He listed it quietly, accepted a fair offer, and was gone before the sentencing. He had come to me once more before listing, stood on my front porch in the same posture as his first call, the posture of a man carrying something he did not know how to set down. He said he wanted me to know he had told the civil attorneys to settle fully and fairly without resistance, that he had reviewed everything, the 3-year log, the camera footage, the engineering assessment, and that he had no interest in protecting Karen from the consequences of what she had done. I told him I appreciated that. He said he was sorry. Again, The second apology was different from the first, more specific, more weighted, the apology of a man who had had months to think about what his wife had done and what it said about things he had not wanted to examine. I accepted it. He shook my hand and went home to finish packing. The pool demolition began in month 3, concurrent with the civil settlement processing. I contracted a licensed demolition team to remove the introduced concrete. The work was complex. The bonding to the gunite shell was extensive in the deep end, and the removal required careful mechanical work to avoid shell damage. My structural engineering expertise allowed me to direct the process in real time, minimizing damage to the existing shell. The deep end required 3 days of careful work. The bonded material was removed in sections. The shell damage was assessed daily. The final damage to the original shell was less extensive than I had feared, 3 sections requiring patching, all resolvable with proper gunite repair. Vera came out on the second day of demolition and stood at the pool edge watching the work. She had been the one to insist on the cameras. She had been the one to say 3 weeks and then law enforcement. She had been the one to specify consequential damages in the civil demand letter. She watched the demolition crew work for a while, then she said, "Do you want to keep it?" I looked at the pool, the introduced concrete being chipped free in sections, the shell emerging beneath it, damaged in places but fundamentally intact. The equipment housing, once buried, now exposed and assessed and found to be salvageable with component replacement. "Yes," I said, "I want to keep it. It's going to cost more to restore than to build new." "I know. Why?" I thought about the 14 months it had taken to build the first time, the specifications I had written, the engineering decisions I had made, the bench along the shallow end that Vera used for reading, the lead light in the deep end that I had replaced 2 summers before Karen buried it. "Because I built it," I said, "and she doesn't get to end that." Vera was quiet for a moment. Then she nodded once, the specific nod of a woman who understood exactly what I meant and agreed with it completely. The restoration took 11 weeks. I was involved in every decision, the way I had been involved in the original construction. The gunite patches were matched precisely. The equipment was replaced with upgraded components. The insurance settlement had covered full replacement value, and I applied the difference between original and upgraded cost from my own resources, because I was not going to restore this pool to anything less than what it had been. The lead light in the deep end was the last fixture installed. I put it in myself, the way I had put in the original, stood in the empty basin, in the space where Karen's concrete had been, and connected the housing to the conduit and tested the circuit. It worked. I climbed out of the basin, stood at the edge, looked at what had been destroyed and rebuilt. Then I called the fill service. 6 hours to refill, chemical balance established over 4 days. On a Sunday morning in late October, I stood at the pool edge and looked at the water. Clear, properly balanced, exactly what I had engineered it to be. The surface caught the Colorado morning light and held it. I swam laps. Then I floated on my back and looked at the sky, the particular high blue of Colorado autumn, the kind of blue that does not exist at lower altitudes, the blue of a place where the air is thin and clear and everything is exactly what it appears to be. Vera came out at some point with coffee. She set a mug on the deck edge within my reach. She sat in her reading chair along the shallow end bench, the bench I had specified for her that had survived the destruction intact because it was built into the shell and Karen's crew had only filled the deep end. She opened her book, the pool pump hummed, the water moved. I floated until my coffee went cold. Then I climbed out, dried off, picked up my mug, and looked at the pool one more time. $40,000 of structure destroyed and rebuilt, 11 weeks of restoration work, a criminal conviction and a civil settlement and a professional license hearing and a house that had sold and a family that was gone. And the pool, exactly as I had built it, standing in the late morning light as though none of it had happened. I went inside, sat at the kitchen table, opened the incident log to the back cover. Beneath the last entry, the 41 photographs I had taken standing at the gate on that Tuesday evening, I wrote a single line. Pool restored, original specifications, full documentation retained, matter concluded. I closed the notebook. Vera was at her desk. The house was quiet. Outside, the pool pump ran its steady cycle. Everything was exactly where it was supposed to be.